So with that, I will call the case. It is from Miami County. It's 128-345, entitled Bruce Betts versus Chad Keenan, Special Administrator of the Estate of Norman Keenan. Who do we have here for the appellant?
Your Honor, Brian Cox for the appellant, Chad Keenan, a Special Administrator of the Estate.
And for the appellee?
Your Honor, Ashley Jarmer and Michelle Stewart for plaintiff appellee Bruce Betts.
And you'll be presenting the argument?
Yes, Your Honor.
All right. Mr. Cox, whenever you're ready, and do you wish to reserve any time for rebuttal?
Yes, Your Honor, if I could have 3 minutes for rebuttal.
That is granted.
Your Honor, may it please the court, Brian Cox for Chad Keenan. Briefly, I just want to touch on the substitution issue. I think that that's been briefed in the supplemental briefings. I'll just say that the motion to substitute Mr. Keenan, while already being granted by the chief judge, was filed just 57 days after the suggestion of death. That was over the holidays and required the opening of an estate and appointment of Mr. Keenan as a special administrator. We believe that that is a reasonable time. No other court in Kansas has held anything less than 6 months to be an unreasonable amount of time, and no other state requires quicker action to substitute a party. Your Honors, the district court here found a 50-50 farming partnership. It also expressly found that that farming partnership was never terminated. It found that the equipment the partnership used was partnership property. And it found that Mr. Betts traded in that partnership property for equipment of his own. Then it awarded all of that equipment to Mr. Betts. That result cannot stand for 2 reasons. First,
before you get into the merits, let's talk a little bit about some procedural issues.
Certainly, Your Honor.
Do we have a final opinion here, and does this court even have jurisdiction to look at your case?
Your Honor, on the jurisdictional issue, this was something that we identified after the docketing statement. At that point, the only court that had the power to address that issue of whether or not this court had jurisdiction was this court, is this court. Your Honor, if you agree with us with the concerns there that the court below did not do 2 things. First, it did not actually rule on it did not rule on 2 claims that Mr. Keenan brought in his counterclaim. The claim for the actual dissolution, the court just never said it was actually dissolving the partnership, although it seemed to take steps that it assumed that it had done so. And second, it never ruled on his claim or his request for an accounting. Without those...
Mr. Cox, I'm sorry to interrupt you, but as you mentioned, it appeared that's what the district court was doing. Dissolving the partnership by dividing the property. Is an explicit dissolution? Are those explicit words required? If we can tell what the district court was doing from its order, is that explicit statement required?
I think it is, Your Honor. Under the Goldman case, Goldman versus University of Kansas, silence is not a denial of a claim. And since the court didn't actually deny the claim or explicitly granted either, I think that silence has to be taken as not having ruled on it. If here the circumstances make it a little bit different, given that it's, I think, a fair reading that the court was intending to do that and maybe it just forgot, then we can proceed to the merits. But it was something that we felt as as counsel we had an obligation to raise when we identified the potential jurisdictional defect. But that also doesn't account for the accounting claim. And as we'll see in the substantive merits side of the case, the lack of an accounting in this case really did create some difficulties, made it harder for the district court to actually decide things. If the court...
I apologize, Mr. Cox. If you think, though, that there isn't a final order, can we get to the merits?
No, Your Honor, I don't think the court can get to the merits.
All right, well then, thanks for your time.
Usual for the appellant telling us we don't have jurisdiction.
Certainly, Your Honor, and again, we felt that was the necessary thing that we as attorneys with our duties of candor and to the court, when we identified the potential jurisdictional defect, that we had to bring it up.
So a failure in the final order I mean, let's be clear. This is quite an order
Yes, Your Honor.
from the district court. Um, the remedy would have been to file something with the district court saying, hey, by the way, we don't think you did all the bits.
In the meantime, risk the potential of running out of time to file a notice of appeal, running out of time to docket the case. And if the trial court disagreed and said it was a final order and was correct, then it may have, lost Mr. Keenan his opportunity to make the appeal. So I certainly think that it wasn't by any means irresponsible to pursue the appeal as well in order to protect those rights. Excuse me, Your Honor. Your Honors, if there are no other questions on the jurisdictional issue, I'll just note that if the court remands on the jurisdictional issue, all of the things that we discuss in the substantive merits are still open. And in fact, there are even some claims that, maybe, or some issues that can be readdressed by the court beyond it, because I think that there's a lot of stuff that won't necessarily be binding when it goes back, since that order will have just been an interlocutory order. Your Honors, on the second issue, Mr. Keenan raised error with the district court's decision on how to dissolve the partnership, if we assume that that was in fact what the court was doing. Under the law, with no written agreement, the Kansas Revised Uniform Partnership, KRUPA, governs the defaults. Dissolution requires a winding up of the partnership business. They're two separate things. They're tied together, but they're two separate things.
But what about the fact that no one mentioned this act during the entirety of the proceedings before the district court? And we're a court of review, so we're to review what the district court did. Is it not unfair for us to say, hey, you didn't use this act when no one raised it?
Your Honor, while nobody below necessarily cited chapter and verse to KRUPA, as we've had the opportunity and have done so at the appellate stage, Mr. Keenan very clearly identified the result or the relief that he was seeking. He asked in his petition, I believe it's paragraphs 25, 26, 27, he asked the court for the accounting. He asked the court to distribute the assets. He asked that he get at least 50% of the equipment that the partnership owned. And so while he didn't specifically cite KRUPA substantively, he was stating the default KRUPA rule based on, with the addition of, it was a 50-50 partnership. The default rule in KRUPA actually is there that in the absence of an agreement otherwise, all of the partners share equally in the profits of the partnership as well as its liabilities. And so while he didn't cite the KRUPA, chapter and verse, he did request that relief, and he asked the district court for that, and it did not grant it. Your Honors, when a court winds up a business, it's supposed to first take all the a partnership. It's first supposed to take all the assets, discharge of the partnership's obligations, credit the partner's capital accounts, and distribute any excess. The court just did not do that here. Each partner is entitled to that settlement of accounts. That's KSA 56A 807. And profits and losses, it's both profits and losses. So we had a number of things here. We had some crop debts. We had some additional debt taken on in order to satisfy those crop input debts. All of that needed to be taken into account. And to the extent that Mr. Betts had some debt in his name for that property, that too is something that would have been taken or should have been taken into account in the winding up of the business assets. On remand, what the district court needs to do is just basically what I said: declare the partnership dissolved, fix the date, and then go through the winding up process. That raises the last issue that's kind of a subsidiary part of that, is really determining what the status of that property, the partnership equipment and machinery is. There's a statute that governs this. It's the default rule under KRUPA. It's KSA 56A 204. Subsections C and D are the two that are at issue here, since the property was all titled in the name of a single partner. They're mutually exclusive, as the Stevens case noted. Subsection C applies whenever partnership assets are used to acquire the property. Here, that was the case. There was a settling up at the end of the here. That settling up accounted for the equipment payments. The equipment payments came out of partnership funds. The new equipment that Mr. Betts purchased, traded in the partnership equipment for in order to purchase the new equipment. He was using equipment that was already partnership property. Since that was partially used, the presumption is that it is partnership property. If Mr. Betts took on additional debt for it, if he paid additional amounts on it, he can ask for those credits before the district court when the district court deals with that in the winding up. But that property is partnership property. Unfortunately, the district court didn't go that way. It just took the old adage, but it's not the law, that possession is 9/10 of the law. But here we've got a specific statute under Krupa that says that that's not the right way to go. I expect that Mr. Betts will argue that this is really just a substantial competent evidence thing, but that's not really what we're looking at here. The determination of whether property is partnership property or not, the determination of those facts that underlie that determination, that is a substantial competent evidence issue. And that was the case in Stevens, where there was a dispute about whether or not partnership property was used to acquire the property. That was a dispute over whether subsections C or D applied. But that's not the case here. The court here in, I believe, paragraph 36, the district court specifically found that Mr. Betts acquired the new equipment by trading in partnership equipment. The court's already made that factual finding. We don't challenge that factual finding. We only challenge the legal result from that factual finding.
So I want to clarify, you're making no claims that there were insufficient findings and facts in the district court's order. What your claim is that they applied the wrong law to those factual findings.
Outside of the, and I don't think it's even a findings of fact, the insufficiency on the jurisdictional issue, outside of that, setting that aside, you're correct, Your Honor.
Okay.
That's absolutely correct. Your Honors, Mr. Keenan asked this court to reverse the district court's ruling, to remand it to do a proper winding up of the partnership's business, to properly categorize the partnership equipment as partnership equipment and included in that. That is, of course, as we've already discussed, if this court finds that it does in fact have appellate jurisdiction over the matter. Thank you.
Mr. Cox, one
Yes.
quick question that is not related to the merits at all, but is Chad Keenan, is that Norman's son or uncle? Just a matter of clarification for the record.
Yes, Your Honor, and I didn't memorize the record citation. That was my mistake in writing a filing. He is his nephew.
Okay.
There was a statement in the trial testimony that he was like a son to his uncle, and I think that's where I got it in my head, that he was his son. I apologize for that mistake. They are absolutely correct in saying that he's his nephew, not his son.
Thank you.
Good morning, Your Honors. May it please the court, Ashley Jarmer for Bruce Betts. Mr. Betts respectfully asks this court to hold it does have jurisdiction over the district court's thorough final judgment and refuse to address the issues that are raised for the first time on appeal. Unless the court prefers another approach, I'll address them in the order we have in our response brief.
Explain what we do about the problem of the district court never dissolves the partnership.
Yeah, well, Your Honor, we would disagree with that premise. We think that everything that the district court was asked to do, it did here. It is true that Mr. Keenan did ask for a dissolution, and then as the case proceeded, the claim continued to narrow. In his initial petition, he asked for a dissolution of the partnership. And as the case proceeded towards trial, I was not trial counsel, but our trial counsel begged and pleaded for Mr. Keenan's counsel to tell the court what the counterclaim was about here. My client was the plaintiff. We argued this case, the partnership was dissolved in 2018. Mr. Keenan disagreed with that position, and he said, no, the partnership was not dissolved, and he brought counterclaims. So as we proceeded towards trial, Mr. Betts's counsel didn't even really know what the counterclaim was about. So he continued to seek clarification. And he said, I really need that trial position statement because without it, we don't even know what we're up against here, Your Honor. The position statement was finally filed, and you'll see as the trial progresses, the arguments that you're hearing today are nowhere. They are not there. The Kansas Revised Uniform Partnership Act is never mentioned, and I understand the argument of saying, look, there's a difference between chapter and verse, KRA 562403. But you have to at least present the concept to the court and let the court know what you're asking them. A trial judge's job is hard enough without trying to guess what the parties are asking them to do.
So it's your contention that the trial judge agreed with plaintiff that it had already dissolved in 2018 and was just clearing up.
Oh, no, Your Honor.
Okay.
I fully concede that the trial court did not find that the partnership was terminated in 2018. And quite frankly, we planned to cross appeal that issue until I looked at the standard of review. It's a substantial competent evidence standard of review, and we would not have been successful on that issue. But the court did resolve all of the partnership issues that were outstanding. I think that the partnership was clearly terminated by the time this lawsuit proceeded. The district court's order uses past tense in discussing the partnership. And every outstanding issue was resolved here. It just wasn't resolved in a way that Mr. Keenan liked the result. There's a difference between not resolving an issue and not liking the district court's result.
What about the accounting?
Yes, good question, Your Honor. The accounting was raised in the initial counterclaim. And as it proceeded towards trial, you'll see it's not in the trial position statement. You'll also see some record citations, and if I can get to that section of my notes here, the appraiser actually testified at trial. The appraiser didn't have a lot of evidence on background information, but he was kind of just saying, here's this equipment, what I think it's worth, here's this equipment, what I think it's worth. But during that testimony, if you'll look at that, Mr. Betts' counsel actually objected because they were getting into issues that they thought were outside of the appraiser's expertise. And Mr. Keenan's counsel conceded at that time that there wasn't a forensic accounting and that the parties had agreed to go forward with the evidence they had. And I quote, "It is what it is." And that's at record 6, page 199.
So you think he wasn't asking for an accounting?
That's correct, Your Honor. By the time of trial, the trial position statement does not mention it. And at trial, there are multiple points where Mr. Betts' counsel said, I want to be sure I'm understanding what you're asking for here. He reiterates what he thinks is before the court. He asked time and time again. And now we have a whole new set of asks before this court that were never properly before the district court judge.
So even if, putting aside whether Keenan's asked for application of CRUPA, are we not obligated to apply that in the case where we have a partnership that is not written down?
I don't think you are when the parties don't ask for it, Your Honor. And the reason I say that, this court, a good example of that is this court's opinion in State v. Battle. That's a probation revocation case. Totally different set of facts, I'll grant you that. But there, the district court did not apply the graduated steps that are now in the Kansas legislature's probation revocation process. But the probation violators counsel didn't argue that. That gentleman was sent to prison for that. So if a person can be deprived of their liberty by their counsel not preserving an argument, I certainly think it applies in the civil context. If I may, I'll address the jurisdiction issue briefly. We think this court has jurisdiction over the district court's final decision. In Nicholson v. Mercer, the Supreme Court reiterated that courts must separate genuine jurisdictional issues from fact or law-based offenses. Simply stated, this court has jurisdiction, and its jurisdiction doesn't go away because an issue is unpreserved. What we actually have here is someone attempting to put this court on a merry-go-round of saying, oh no, the issue wasn't preserved, so we get to go back and have a new trial. You heard counsel say this morning, what they actually want to do is open this whole thing up again. Both partners in this case are elderly gentlemen. One of them has since unfortunately passed away. This case does not need to be retried. The district court heard evidence over 4 days. At the end of the trial, he explicitly asked both counsel, is there anything else? They said, no, Your Honor, I think we've killed it. That's a quote from Mr. Keenan's counsel. I don't think we need to go back and have something start again that has been definitively decided. And there was a process. If Mr. Keenan's counsel actually thought what he's saying now is accurate, KSA 6252 and Rule 165 say after a bench trial, if you think the district court didn't do what they were supposed to do, you tell the district court that. And what that does is it gives the district court the opportunity to decide whether they agree or whether they're going to affirm their decision. But when that's not done, you waive the issue. And that's the whole problem here. The problem is not that the appeal was docketed. The problem is that the issues that they want to raise, they can't raise unless they either frame them as a jurisdictional issue or an issue of law that is preserved. Neither one of those is actually before this court. Again, the Kansas Revised Uniform Partnership Act, the record, it's not there. It's not in the petition. It's not anywhere. And what they're asking this court to do is apply statutory presumptions that are rebuttable to a set of conflicting facts where the district court explicitly held, I don't find either the plaintiff or the defendant credible here. The district court did the best it could with the evidence before it. It found neither party had met its burden of proof, and then it divided the equipment equitably between them based on the facts and law provided to the court at that time.
Is it not the court's responsibility to know the law that should apply to the arguments, though?
But it is, assuming the court understands what those arguments are. First of all, I don't think the court has an obligation to say, hold on, doesn't the Kansas Revised Uniform Partnership Act apply here? Again, I would point this court back to the Battle case. Even when a liberty interest is at stake, it's a party presentation state. The party has to tell the court, Your Honor, this is what we're asking you to do, and this is the law we're asking you to apply. It's not an error, especially here when the Kansas Revised Uniform Partnership Act at bottom is a gap filler and is an equitable principle. And the court here was specifically asked, we'd like for you to do what's equitable here. And then on appeal, they're saying it was erroneous to do what was equitable here. So I'm unsure what the district court judge was supposed to do here when it was unclear what the counterclaims even were. And then the law was not cited to the court. The court did what was asked of them, and the court was never asked to clarify their decision. Finally, I would just ask really quickly on the involuntary dismissal issue. We did raise that issue. Mr. Keenan did unfortunately pass away during this appeal. We think an unreasonable amount of time passed, at least to advise the court of what was happening with the case. Otherwise, we would submit that issue on the brief. Unless the court has any other questions, I would close my argument and sum up if I may. Here, the issue is the district court did not err in failing to sua sponte do something no one asked them to do. Mr. Keenan asked this court to reconsider the district court's equitable determinations in distributing property and weighing what everyone concedes is completely competing evidence. Mr. Cox is correct. I am going to tell you the standard you're operating under is substantial competent evidence here. And under that standard, it is clear the district court's decision is supported by overwhelming evidence. We'd ask you to affirm and let the parties go about their day. Thank you, Your Honors.
Thank you.
Your Honors, for rebuttal, a couple of points, very brief, that I want to make. When you look at the trial transcript, you clarified with the respondent's argument there that, yeah, the district court did in fact find that the partnership did not dissolve in 2018. That was a factual finding. They haven't challenged it in a cross appeal, so that's established. But the other thing that was going into that argument in 2018 was that Mr. Betts presented this agreement on the dissolution that he claimed existed back in 2018, where they agreed that he was going to do a little bit of farm work and he was going to get all the for Mr. Keenan, and he was going to get all of the equipment from the partnership. The district court, in finding that the dissolution did not happen then, it was not a dissolution by agreement of the parties, also found that that agreement did not exist, that there was no such agreement. And so when you look at the trial transcript, if you get to the point that the partnership's not dissolved in 2018, and then there was also an argument about it maybe having been dissolved in 2020, but there aren't any findings and the court doesn't find that it was dissolved in 2020. But whatever point you eventually do get to, the partnership has been dissolved at a later date or is dissolved by judicial action. The question of, okay, now how do you distribute everything was not necessarily the primary point of contention at trial. It certainly was there, but it was not necessarily the primary point of contention. And so the request from Mr. Keenan, it was there in his counterclaim. The request from Mr. Keenan about the property was there in closing argument that he wanted 50% of it. Didn't say Krupa, but he did ask for 50% at every stage. If your honors have no further questions, that's all that I have.
Apparently not. Thank you, counsel, very much for your briefs and your arguments today. As I said earlier, we will take the case under advisement and get a written opinion out to you and your clients just as soon as we can.